Our final morning case will be Blackwell versus Franchi. Mr. Couch.
Mr. Chief Justice, and may it please the Court, my name is Stephen Couch. I'm appearing for the appellants, or the Dean and Deborah Franchi. If I may, I'd like to reserve 3 minutes for rebuttal.
So be it.
The issue before the Court this morning is of fundamental importance to really all... I'm sorry, Your Honor?
Okay, please proceed. I'm sorry.
Thank you. The issue before the Court this morning is really of fundamental importance to really all homeowners in the state of Michigan, and that is the duty that they owe to the social guests they invite to their home, and specifically the duty owed to a social guest who enters into a darkened room in the home of her own volition. And so we're approaching this from two directions. First, we would ask the Court to look back to the case of Singerman versus Municipal Services from 1997 and to adopt the reasoning of Justice Weaver in that case, that darkness can in and of itself be an open and obvious condition. And even if the Court does not go back to Singerman and does not adopt that standard, to nevertheless reverse the Court of Appeals because there simply was not adequate evidence in our factual record to support the reversal of summary disposition. And I'll be happy to waive the balance of my free fire.
So Singerman's an invitee case?
Yes, Your Honor.
Right, so how does that really come into play here?
Well, if you're talking about an open and obvious condition, it applies to an invitee or a licensee. And the issue in Singerman was whether or not the plaintiff...
Right, no, I'm familiar with the case. I guess the question I have is it really a question of open and obvious, or is it a question of duty, given it's a licensee?
Well, we think it's both. We think that it is a question of open and obvious in this case, but even if the Court disagrees, that there still is no duty in this case because, first of all, Ms. Blackwell, by her own admission, saw the room was dark when she walked into it.
So let me just slow you down.
Certainly.
What comes first? An analysis of whether there's a duty or an analysis of whether whatever's there is open and obvious?
Well, it's all of a piece, Your Honor. I mean, the open and obvious analysis is a part of the duty analysis. And so whether you get there through open and obvious or whether you get there through a test specifically geared towards licensees. I guess the question is, if there's no duty to warn of a defect, would there be any duty to warn of an open and obvious defect? No, Your Honor.
The only duty to a licensee is to warn of hidden dangers or dangers that a licensee might not normally appreciate. Isn't that right?
That is correct.
Okay, so obviously an open and obvious danger may pose such a danger, but typically it's the licensee relationship or the invitee relationship that triggers the explicit open and obvious analysis, isn't it?
Typically it is. That is correct. And with respect to this case, first of all, there was no hidden danger to speak of, although the Court of Appeals viewed the step in the dark room as a hidden danger. The problem with that analysis goes to the next prong, which is knowledge, is that the homeowner has to know or should know that the hidden danger exists. And nowhere in our...
You don't think it's like... You don't think a step creates a hidden danger in the sense that it's kind of unexpected, you're not anticipating it, you're not going down to like the basement, you're not going down to a different level. It's only one step, it's not two steps, it's not three steps, it's one step. You don't think that that in and of itself kind of creates a certain sense of surprise upon the visitor, especially when the visitors are told they should go and put their belongings in that room?
Justice Bernstein, thank you. There are several pieces to that question I'll try to approach in order. First of all, with respect to the step, the case law in Michigan consistently has been that a single step by itself is not a hidden danger. The issue in this case becomes whether the step in a darkened room is a hidden danger. And that's what the Court of Appeals looked to.
The question is the whole emphasis of this situation the darkness, right? So is your basic argument is the fact is that because the room was dark and there was no light within the room, that in and of itself created the open and obvious danger. Is that correct?
The darkness in and of itself, we view that as being open and obvious.
So then my question would be then, what if it was lit? What if you had lights on? What if there was a strobe light on it? Wouldn't you then come back and then say, well, wait a minute, because it was so well lit, you should have been able to notice the obstruction or notice the danger. So how don't you kind of have a situation where you're kind of going so far in one direction that it kind of loses rationality because you're basically saying, well, it's dark, so you can't see it, but now it's light, so you should have seen it. So what if it's dim? Does that matter? You can't, how do you get through this notion that it's open and obvious if it's dark, but no, now it's open and obvious if it's light? How is one supposed to function in this situation?
Well, I think one has to look at all three factors. To go to your strobe light example, if I may, I think a strobe light may be an entirely different aspect to this. It may be distracting to a person. That's
I was just having
really
fun with you, but what if it's just lit up? It's not a strobe light, so the lights are on and the room is lit up and the obstruction is there and you fall over it.
If the lights are on, then traditionally the case law in Michigan is that a single step by itself it's not a hidden danger, it's not an unreasonable danger, and so there would be no liability attached to that step. In this case, what we have is a plaintiff who knew she was walking into a darkened room. And I want to, in conjunction with that, speak to the knowledge piece a little bit, because there is broad conflict as to whether the homeowners in this case had knowledge that the light was off, and that's important because that hidden piece is the hidden defect. Nobody who was deposed in this case could state that the Franchis were in a place where they would have known or should have known that the light was off. Dean Franchi testified at his deposition that all the lights were on the first floor. That's our starting point. So now we look to the other witnesses. Ms. Blackwell testified that she walked back from the foyer. She didn't know where Deborah Franchi was at that time. India Simmons testified they went back to the kitchen, and Deborah was back there, but Susan's the one who suggested putting the purses in the mudroom. Ebony Wisnant testified that Susan and Ebony, it was their idea to go into the mudroom. Nobody places the Franchis in the vicinity, and nobody can attribute knowledge to them. And so there again, that prong is not satisfied in this case.
Counsel, can I get back to how to think about what the plaintiff did not do in entering the room, didn't turn on the light to figure out what was there?
Certainly.
I'm just trying to figure out where to put that doctrinally, how to make sense of what the Court of Appeals says is we're a comparative negligence state, and a jury might well say the plaintiff is comparatively negligent to such a degree that you get a victory then. Obviously that's not what you want, because then you have to go to a jury trial, and I understand that's why we're here, but I'm just trying to fit in the plaintiff's conduct in our doctrinal framework. So help me with that.
I think the issue is in this case when someone who is similarly situated to Ms. Blackwell encounters a room, say, that's darkened, and leaving aside whether she turns the light on or not, if she walks into that room on her own volition, then she is doing so not knowing what's inside of that room. As the dissent notes below, it could have been a toy, it could have been a laundry basket, there could be anything in there. She doesn't know what's in there.
No, I get, so you're agreeing with me that she may well be she may be negligent as well. That doesn't help me think about how her conduct does any work in framing the C-10 question, right?
Well, I think that goes to the third prong of the test in Stitt versus Holland Abundant Life. The third prong is if the licensee does not know or have reason to know of the dangers involved. Our position is that once the plaintiff walks into that darkened room, the plaintiff has to presume there's some danger in walking into that darkened room of her own volition. Whether she may not encounter any danger, but if she does walk into a room
it still sounds like comparative negligence to me. I'm trying to see how it helps, how her conduct changes the duty or the, the open and obviousness of it. One answer might be your answer, that darkness is open and obvious, even as weird as that is to say. I understand what you're saying. But another might have been, I thought you might have said, well, the open and obvious doctrine as developed in this jurisdiction requires that it be something that's noticeable upon casual inspection, and maybe upon casual inspection, assumes that you don't walk into a dark, you casually inspect by looking for lights, or
Sure.
I don't know. I'm trying.
That is a possibility also. I would note that, Your Honor, I understand the counterintuitive nature of darkness as an open and obvious condition. There are a few states that have recognized that. A panel of the Court of Appeals of this state recognized that just 2 weeks before our case was decided in an unpublished opinion. There is history there for reaching that conclusion that one can, upon casual inspection, see an area is dark and either go headlong into it or choose to avoid it.
So if it was not a step, but you knew I was going to go here, a shark tank. If the mudroom was a shark tank and that with no cover, that's just where they keep their pet sharks. It's just a big, and the lights were out, and she walks, to put her purse in what she thinks is the mudroom, but it's a shark tank. She falls in the shark tank. She gets eaten by a shark. Is your view still that there's no duty because she could have turned the lights on?
I think that the difference there might be that when we're dealing with a shark tank, that gets us closer to Appellee, that gets us closer to the Knight case, where there is an unreasonable danger when the person, in those cases an invitee, when that person encounters a loading dock or something of that nature. That's very different from a single step. Steps have consistently been outside of the realm of unreasonable danger. A shark tank would be very different.
Well, how? I don't quite understand your answer.
We're trying to figure out how it's different doctrinally. I mean, the way the Court of Appeals said, you may not, in that case, her comparative negligence isn't going to do a lot of work, because people are going to say, like, well, yeah, she's not negligent for, she's negligent for missing a step because, she didn't turn on the light and figure out that there was a step, but, Shark Tank, who's going to expect that? But but doctrinally, how does it do work in defining duty? Like I understand that if the lights are on, a step has been held to be not has held to be an open and obvious danger, right? A step like this. Doesn't
Correct.
sound like there's anything tricky about this step. It's not a trick step that, I don't
That's
know.
correct.
Right. It doesn't have a spring gun or anything.
No, and again,
but the step in the dark, we haven't said that yet. So I'm just trying to figure out how to frame it in terms of duty.
well, I think, again, the issue is that when we're talking about, again, we're talking about a single step. When someone steps into a darkened room, and again, this does get into the whole knowledge issue of what the franchise does. If they had a shark tank, they would warn everybody who walks in the door, there's a shark tank over there, don't go near there. And if they didn't, that's shame on them. In this case, simply a single step or toys or a laundry basket, once someone walks into that darkened room, it should be presumed that, without going further, there may be a danger there that they don't know about. And that's, I think, how it fits into the test of STIT.
How does it fit if I'm coming to your house and it's dark and it's winter and you haven't, there's ice all up and down your sidewalk and I fall on the ice? Would this have an effect as it pertains to, is it better for you as a home? Is it better for you then just to keep it dark or to have lights on the outside of your house?
I think in the instance of ice outside of a home, I think at that point you get into some kind of special aspect type of analysis, where I don't think that darkness would necessarily save you.
Why?
Because if we're talking about ingress and egress from the home, if I understand your question correctly,
Yeah.
then I think at that point you're talking about a special aspect. We're not even open and obvious in any framework would apply.
So is that something that you would then say that ingress, egress would have a factor in a case of this nature then? If you're leaving or entering, the darkness wouldn't make a difference if you didn't have a light outside?
Yeah, if there were no alternate way in or out, and that's not the case here at all. This was a room off to the side, and by happenstance, that room went out to the garage, but no one was entering or exiting through the garage. So the ingress and egress analysis doesn't apply.
So does
here.
it matter then? I just want to understand,
Sure.
again, the jurisprudential, and you're doing a great job. I'm asking you a lot of
Thank you,
questions,
Mr.
and I appreciate the work that you're doing in terms of our conversation. What if it was the kitchen or the dining room or another room that was, is your argument then that because this room was off to the side that made a factor? What if it was a room that was, what if it was a room I'm passing through on the way to get to where everybody else is? So like I've come into your house, everyone says, oh, we're all meeting in the back, or we're outside on the patio, and I'm traversing through the house, and then an injury ensues because I've gone through a dark place and fallen down. Does it matter where the room is located, or is it just the darkness?
I see my time has expired. If I can just address your
That's okay, you can
briefly.
answer.
I think in that instance, darkness by itself might not save a homeowner in a licensee type of case, because if it's a party where people are passing through, like down a hallway, for example, there's a greater likelihood in that case that the homeowner is going to have knowledge that there's a problem in there.
Okay.
And I think that that might pose a different issue with respect to liability that's not present here.
Okay.
Thank you, Your Honors.
Thank you, counsel. Mr. Oliver?
Good morning. May it please the court, Kevin Oliver, appearing on behalf of the Appellee plaintiff, Susan Blackwell. The hidden danger in this case is the step. The step is the hidden danger. The defendant's the only ones who knew about this step. Defendant Dean Franchi testified that, in fact, he knew of the step, and he knew that the light was off at the time that Ms. Blackwell was entering into the room. He also knew that it is unreasonably dangerous because the floor was dark. The room, he knew he had no windows and was always dark. Even with the light on, he indicated it was dark. I think, and again, he's the only one who knew of the step. Everyone who went and was with my client, Ms. Blackwell, had no idea that the step was there. In fact, they testified, that being Ms. Simmons and Ms. Weisenhout, that had they been in the position where Ms. Blackwell was, that they would have fallen also, because you couldn't see the step. You cannot see it, not only because it was shrouded in darkness, as Justice Gleiser indicated, but you couldn't see it because it looked like it was even with the floor as they're walking into the room. So that being the circumstances involved here, it's certainly a question whether an open obvious, because a casual observation could not see it, as by the witnesses. But in fact, the defendants knew of the step. They should have known of the danger of the step, given what the testimony is I just went over, and that is the duty there to then advise Ms. Blackwell of it, especially when they tell her to use this room. This is the room that you were to use when, or to go into there. It wasn't on her own volition. She was advised by either Ms. Franchi or Mr. Franchi, that's uncertain, to use this room to drop off her purse or to drop off the
Because I think Justice McCormick has really asked the critical question here, and I haven't really seen at least what I consider to be an appropriate response, and that is, what is the larger framework by which we look at this kind of case? That's why we've granted in this case, or we've chosen to hear the case, because we think what occurred here is a sufficiently recurrent kind of accident that it's worth the time of this court to try to assess what the larger questions, what the larger premises are that we ought to bring to this kind of case. And of course, it seems to me it's not simply the darkness that's at issue here. It's also the fact that the mudroom was apparently separated from the hallway by a door, or by a door-sized entry. It was separated by an entryway that was about the size of a door. In common sense, I would suggest, indicates that where there are two areas of a home that are separated by such an entryway, it is often a distinct possibility that the floor levels will be different. So it's not just the darkness, it's also the fact that apparently the plaintiff here was entering a different part of the home, and that different part of the home posed, if you want to call it a danger, or at least the prospect that there might be different dimensions and there might be steps leading to that different part of the home. But neither of you has responded to Justice McCormick in what I think would be a relevant way, and that is the starting point. The starting point to this kind of analysis, I think, has been articulated in a number of common law cases of this court in recent years. And that is, I'll quote Bertrand, one of those cases in which they say, it is a long-standing common law principle that a reasonably prudent person will look where he is going, will observe the steps, and will take appropriate care for his own safety. I guess, at least in my view, a good argument can be made that a reasonably prudent person, when taking appropriate care for his own safety, will turn on a light switch before entering a dark room, particularly when that person is unfamiliar with the room. What's wrong with that as a starting point?
Well, that goes to the comparative duty of the plaintiff. It doesn't go to the duty of the homeowner and the premises owner here. The premises owner here has indicated, given the circumstances of our incident, should have known it was unreasonable and advised them. The fact that it was dark in this room and Ms. Blackwell did not turn on the light goes to comparative duty. She does not have an affirmative duty based on the case law, and I believe Justice Shapiro mentioned that in the opinion and distinguished Novotny as to whether or not she has a duty to take an affirmative action there.
So the hidden danger in this case about which the defendant should have warned plaintiff is that if you don't turn on the light, all sorts of scary dangers might present themselves to you. One would be that you might encounter a step. Another might be that you run headway into a sink and you bump your head and you hurt yourself. And there are countless other dangers that have to be warned of, perhaps including the shark tank there, too.
That goes to comparative.
You can only get to comparative if we find a duty in the first instance, and I guess that's the real question. It's not an invitee, it's a licensee here.
That's true.
It's a substantially lower duty.
That is correct, and I understand that. And I think that, we all know the law there, and the duty is one that they need to warn if the licensee is unable to successfully or unable to observe that unreasonably dangerous condition. And then the testimony of all the witnesses, the photos, all of the evidence points to the fact that there is no way that they should have known that there was a step there. And it is the step that is unreasonably dangerous, sir, not the darkness.
Why is it that a person is unable to observe when they have the ability to turn a light on? You can't argue that's comparative when they do have the ability to turn a light on to see what there is there to be seen.
Yeah, she did not see a light switch on the outside, so she's going into the room. She can turn on the light switch as she enters the room, but the fact that the step is the unreasonable dangerous condition here does not prevent her from walking into the room even when it's dark, because there was no switch.
You concede the case law suggests that steps are not, they're unremarkable, they're not dangerous.
That is true, but not in this
and
situation.
So your position is that it goes from a reasonable condition if the light is on to an unreasonable condition if the light is off.
Well, even with the light on, you can't see that there's a step there. It still looks very level. It's not open and obvious even with the light on. You can see that in the photographs.
So they had a duty to warn about a step regardless of whether the light was on or off.
Well, certainly with the light off, but you can't see it without it, and they advised her to go in there, yes.
Well, future homeowners will want to look at this case and know what they have to do in order to avoid being placed in the circumstances that defendants in this case have been placed in. Would it be sufficient in the future that I or you or any other homeowner who happens to have a licensee coming to their home warns that licensee that when you enter this home, you could trip over something whenever you enter a dark room and are unable to see the floor? Would that transform what is otherwise a hidden and unknown danger into a known danger, and thereby relieve the defendant of any liability for the kind of accident that occurred in this case. Is that sufficient for a homeowner to undertake in order to avoid liability?
You're asking me if a licensee...
I want to know if you would bring a case if that happened, if the plaintiff had been warned. We have a number of dark rooms in this home, and any one of them might contain something that you don't anticipate or expect. So turn on the light before you go there. Does that transform something that triggers liability toward the licensee into something that protects the homeowner?
Well, I don't think necessarily that is required.
That's not good enough. It's not good enough to warn them of a danger.
Well, it's certainly not required by the law to warn them of that danger, as it is, as you stated. It certainly is in our circumstances.
What would relieve the defendants in a case such as this from liability? I want to know if I'm going to have a party, if I'm going to have people come over, strangers, for whatever reason. I want to know what I need to do in order to insulate myself from being brought to the Michigan Supreme Court in a case just like this one. What do I need to do?
Well, I think you need to advise them of the danger that is known to you.
And I've just done that. I've warned them of exactly the danger they confronted here and presumably were harmed by. Why doesn't that insulate me? You're rejecting the idea that it does insulate me.
Well, it didn't happen in this particular instance.
I understand
obviously.
it didn't happen here.
Counsel, when I go to people's homes as a blind person, it's incredibly custom every time I go to someone's home because the people know the fact that I can't see. They know that I render and need assistance. When I go to someone's home, it's pretty customary that people will say, "Oh, Richard, just so you know, if you're going in this direction, be careful. There's a step." That's very common. People will always do that. If I'm going to visit their home, people will go out of their way to basically say, Richard, if you're just be careful if you're going here. There's this one step, and they'll usually always say, people always fall on that step. That's what they always say. They'll say, "Oh my God, they have this one step here. I don't know why it's there." People always fall on it. If a homeowner does that, would that help in that situation? If somebody were to say, you're coming to the house, "Hey, look, if you're here in the home, if you're going here, just be careful because if you go into this room, people always trip. There's always a step that people fall on all the time." Would that help you in that situation?
Certainly, yes.
No.
It would. I agree with that, and I think that's analogous to the situation that we have here. It's that you could not see the step. The step was not open and obvious, and certainly a question of fact is whether it's open and obvious, but the duty upon the homeowner to say, take a look, there is a step there, or there could be a step there. I think that is something that should have been done.
Any further questions?
Thank you.
Thank you very much. Is there any further time left? Okay, your time's up. Okay, thank you very much. We'll stand adjourned until 12:30 today.